So I'm instructed by the core participants, the Fire Brigades Union and Unite the Union. I'm also asked to mention other trade unions which are not core participants, though some applied and were refused that status. These other unions are the Communication Workers Union, CWU, the GMB Union, the National Education Union, NEU, the National Union of Journalists, NUJ, and the National Union of Rail, Maritime and Transport Workers, RMT, and the Public and Commercial Services Union, PCS. Some of these unions may apply for core participant status in due course, and other unions not represented today may join them. It'll depend on the nature and extent of evidence emerging of infiltration and surveillance of those unions by undercover police officers. It'll also depend on resources since, as you will appreciate, sir, unemployment has risen by 1 million since lockdown, and union membership levels and hence union subscription income is consequently imperiled. So the first point my clients wish me to emphasize to the inquiry is that trade unions are lawful organizations which play a vital role in any democratic society. Of course, even lawful organizations may commit crimes, but undercover infiltration or surveillance of a lawful organization will require a full and proper justification by reference to a reasonable anticipation of criminal activity. My clients believe that they were subject to undercover police surveillance and infiltration, and they do not believe that there will be shown any such justification. They'll also wish to know what happened to the information gathered by covert police operations. There is evidence that some of it may have been supplied to third parties for the purpose of blacklisting active trade unionists from work, as Mr. Smith of the Blacklist Support Group will develop. I'll mention this later. In addition to the concern that there has been unjustified spying on trade union activities which are not merely lawful, but also fulfill an essential democratic function, the NUJ has an additional concern. It considers that undercover policing has sought clandestinely to glean from journalists information as to their sources for published material, a serious incursion into another fundamental aspect of democracy and equally unjustifiable. The NUJ has written to the inquiry separately about this. Though it may appear to be uncontroversial, my clients wish me to explain how, through industrial and political efforts, the law was changed so that trade unions and their fundamental functions ceased to be deemed criminal and became lawful. It's relevant to the question of any justification for covert surveillance of trade unions. Trade unions in a recognizable form have been in existence in this country for the best part of 300 years. The description by Sidney and Beatrice Webb in 1894 of a trade union as a, quote, continuous association of wage earners for the purpose of maintaining or improving the condition of their working lives remains accurate. This function is primarily achieved by union representatives, lay or full-time, representing workers in bargaining with employers with a view to achieving collective agreements setting terms and conditions of employment. Whether agreement is reached and the content of such agreement, if it is reached, depends not just on the exchange of persuasive argument, but on the relative strength of the bargaining position of each side. From the union side, that leverage sometimes derives from an insufficient supply of labor, but more usually derives from the threat and sometimes the use of industrial action. Unions have also sought to achieve the purpose of maintaining and improving the condition of their working lives by promoting legislation to that end and opposing legislation which does not. This has inevitably led to the funding and promoting of political parties. Questions of the lawfulness of trade unions have therefore turned on the lawfulness of the existence of trade unions, the process of collective bargaining, the organization and conduct of industrial action, including picketing, and the political activities of trade unions in promoting legislation and supporting political parties. In the past, these issues have involved the criminal law to a very great extent. The very existence of trade unions was a criminal offence under the Combination Acts of 1799 and 1800. Though repealed in 1824, the formation of trade unions could be criminal on other grounds, such as the taking of an oath, as the famous case of the Tolpuddle martyrs in 1834 showed. The Trade Union Act 1871 legitimated trade unions as lawful in both civil and criminal law, but only by exempting trade unions from the civil law of restraint of trade, which would otherwise have rendered them unlawful. That exemption is still a necessary protection against competition law and is found in Section 11 of the Trade Union Labour Relations Consolidation Act 1992. So, trade unions are organisations which have had parliamentary legitimacy for the last 149 years. Today, they are defined in Section 1 of the 1992 Act by reference to their principal function of regulating relations between workers and employers. The Act provides mechanisms for the listing of trade unions by the certification officer and their certification as independent from employers. All the unions I represent today are both listed by the certification officer and certified by her as independent. So collective bargaining was regarded by the law as a restraint of trade, and the enforcement of collectively agreed wage rates was accordingly a criminal conspiracy, as cases such as... I'm so sorry, sir.
I apologise for interrupting you, but I'm afraid you're going too fast for the stenographers. And
oh, I'm so sorry.
I know you've supplied a written statement which you are following carefully. However, could I ask you to slow down, because they do have to take down what you actually say as well as what you've told us you're going to.
So I'm very happy to slow down. I'm in perpetual fear of running out of time, as you appreciate.
But don't worry, for reasons that are not outside your control. In fact, we have more time today than I had anticipated, and we are not under quite the pressure that we were.
I'm very grateful, sir. I shall slow down, and I apologise to the stenographers. So collective bargaining was regarded by the law as a restraint of trade, and enforcement of collectively agreed wage rates was accordingly a criminal conspiracy, as cases such as the Crown and Journeyman Tailors of Cambridge in 1721 show. During the 19th century, however, collective bargaining and collective agreements ceased to be regarded as criminal or indeed unlawful. By the end of the century, Parliament accepted the reality of collective bargaining, for example, by the Fair Wages Resolution of the House of Commons in 1896. And by the end of the First World War, the promotion of collective bargaining had become the policy of all governments up until 1980. Chapter 1 of Part 6 of the 1992 Act is devoted to collective bargaining. The threat of a strike in breach of contract, as most are, was regarded also as a crime, conspiracy, Crown against Bunn in 1872, and so was picketing, Crown against Hibbert in 1875. Only by the Conspiracy and Protection of Property Act 1875 did they cease to be criminal offences in themselves. However, the organisation of industrial action remained a civil wrong, Taff Vale Railway in 1901, until the Trade Disputes Act of 1906. Since that act, trade unions have been free to organise and threaten industrial action in contemplation or furtherance of a trade dispute, as the golden formula of the 1906 Act puts it, replicated now in Section 244 of the 1992 Act. By 1942, Lord Wright was able to say in the Crofter Hand-Woven Harris Tweed case, Where the rights of labour are concerned, the rights of the employer are conditioned on the rights of the men to give or withhold their services. The right of workmen to strike is an essential element of collective bargaining. As is well known, the organisation of industrial action has been the subject of various statutory interventions since 1906, some diminishing civil liability, some expanding it. The latest set of restrictions were contained in the Trade Union Act of 2016. The right to strike is now well established, the balance being held in the light of the UK's international obligations. Lord Justice Elias encapsulated the principles in the leading case of London and Birmingham Railway in 2011. He said, although the common law recognises no right to strike, there are various international instruments that do. See, for example, Article 6 of the Council of Europe's Social Charter and the International Labour Organization Conventions 98 and 151. Furthermore, the European Convention on Human Rights and Fundamental Freedoms has in a number of cases confirmed that the right to strike is conferred as an element of the right to freedom of association conferred by Article 11 of the Convention, which in turn is given effect by the Human Rights Act. The right is not unlimited and may justifiably be restricted under Article 11.2. He went on. There is one respect, however, in which I think that the recognition of a right to strike does have a bearing on the issues before us. Counsel for the employers submitted that since the unions were seeking to take advantage of an immunity, the legislation should be construed strictly against them. There is undoubtedly some authority to support that submission. See, for example, Express newspapers per Lord Denning. But I do not think that is a sustainable argument today. The common law's focus on the protection of property and contractual rights is necessarily antithetical to any form of industrial action, since the purpose of the action is to interfere with the employer's rights. The statutory immunities are simply the form which the law in this country takes to carve out the ability for unions to take lawful strike action. It's for Parliament to determine how the conflicting interests of employers and unions should be reconciled in the field of industrial relations. But if one starts from the premise that the legislation should be strictly construed against those seeking the benefit of the immunities, the effect is the same as it would be if there were a presumption that Parliament intends that the interests of the employers should hold sway unless the legislation clearly dictates otherwise. I do not think this is now a legitimate approach, if it ever was. End of quotation. So political interventions by trade unions were initially confined to promoting legislation to legitimize unions and on matters of health and safety at work, then expanded to supporting Liberal Party MPs and subsequently founding their own political party, the Labour Party, and funding its MPs and candidates. Such political activities were found to be unlawful in civil law, though not criminal, by the famous Osborne judgment in 1910. Legal regulation was substituted for unlawfulness by the Trade Union Act of 1913, the provisions of which are largely reproduced in the 1992 Act, mostly unchanged, though the 2016 Act has altered the scheme in some particulars. So what this review of domestic law shows is that there can be no legitimacy or justification for the infiltration or surveillance of trade unions by virtue of their mere existence or in the execution of their usual functions. Parliament has taken these matters out of the criminal law and thus placed them outside the proper sphere of operations of the police. Instead, Parliament has chosen to regulate these matters by means of the civil law enforced by employers, members, and the state regulator, the certification officer. Of course, trade unions, their officers, and their members are human beings and thus capable of crimes, even while acting in their trade union capacities. Fraudulent claims for expenses, breaking the speed limit, parking on double yellow lines, obstructing the highway, obstructing the police in the execution of their duty are offences that do occur from time to time. Occasionally people get carried away and threaten violence when they should not. No doubt there is other conduct committed by trade unionists in the carrying out of trade union activities which would currently be regarded as a crime. But since the removal of the criminal law in the 1870s, no one can seriously suggest that trade unions in the United Kingdom have carried out any criminal activity, and certainly none which could in any way justify undercover police surveillance or infiltration of trade unions. My clients would share with Mr. Peter Francis the view that while, quote, undercover policing can be a legitimate policing tool, essential to effectively combat serious organized crime and prescribed terrorist organizations, there is a level of serious criminality that must be reached before the state is justified in using the tactics of undercover officers. Lord Justice Elias had referred to the international dimension, the legitimacy of trade unions and their right to participate in political democracy, to bargain collectively, to organize and support their members in exercising their right to strike and to picket, is recognized and protected by a raft of international treaties ratified by the United Kingdom. There's no need to review them in any detail, but their longevity and extent is worth mentioning. The founding of the International Labour Organization in 1919 as part of the Versailles Peace Agreement recognized the fundamental right of trade unions to exist and to act as such for the protection of the interests of their members. It did more by recognizing the fundamental importance of trade unions in democratic societies and to the maintenance of peace. Almost immediately after the German surrender in the Second World War, the victorious Allies signed the ILO's Declaration of Philadelphia at its conference in May 1944. This began by stating, "The conference reaffirms the fundamental principles on which the organization is based, and in particular that A, labor is not a commodity, B, freedom of expression and of association are essential to sustained progress, C, poverty anywhere constitutes a danger to prosperity everywhere, and D, the war against want requires to be carried on with unrelenting vigor within each nation and by continuous and concerted international effort in which the representatives of workers and employers enjoying equal status with those of governments join with them in free discussion and democratic decision with a view to the promotion of the common welfare," end quote. Trade unions were thereby recognized as not merely legitimate, but a necessary pillar of democracy. The United Nations Declaration of Human Rights of 1948 contained the rights of freedom of assembly and association. In 1949, the ILO adopted its most fundamental convention, number 87, which requires member states to guarantee the existence, autonomy, and activities of trade unions. Of particular relevance to this inquiry is Article 3 of that convention, which states, quote, "Workers and employers' organizations shall have the right to draw up their constitutions and rules, to elect their representatives in full freedom, to organize their administration and activities, and to formulate their programs. 2, the public authorities shall refrain from any interference which would restrict this right or impede the lawful exercise thereof." In 1950, the ILO adopted an almost equally important convention, 98, which guarantees the right to bargain collectively. The European Convention on Human Rights of 1950 contains the right to assembly and association in its Article 11, but adds to the right of freedom of association, the right of everyone, quote, to join trade unions for the protection of his interests, unquote. That latter phrase is the basis of the judgment of the Grand Chamber of the European Court of Human Rights, that the right to bargain collectively is, quotes, an essential element, unquote, of Article 11. That's the case of Demir and Beykara and Turkey in 2009. The court has also in many cases recognized the right to strike derived from that phrase, and I've cited some of the authorities. It's also recognized the right to picket effectively, even if that obstructs the highway. And again, I've cited some cases in the written submission. Of course, these rights are not unlimited, but restrictions on them, whether imposed by domestic law or by acts perpetrated or permitted by the state on a particular occasion, must conform to Article 11.2, which requires that such restriction be, quote, necessary in a democratic society in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. The standard of necessity in a democratic society is, in our submission, a high one. There are many other treaties which have long been ratified by the UK and which protect trade union rights. The European Social Charter 1961, the International Covenant on Civil and Political Rights 1966, the International Covenant on Economic, Social and Cultural Rights 1966, the Charter of Fundamental Rights of the European Union of 2000. So the purpose of this exposition of the law on trade unions is to make clear that trade unions are lawful and respectable organizations which pursue activities recognized and protected by both domestic and international law. They have emerged from the long night during which they and their essential activities were classed as criminal, through the grey dawn of civil unlawfulness into a daylight in which the law regards trade unions and their functions as entirely legitimate, though subject to restrictions. Trade unions serve an essential function in a democracy by representing the interests of working people, not only at work, but in many institutions of society. They act as a balance to the growing power of multinational corporations. The need for trade unions has been highlighted by the consequences of COVID-19, with tens of thousands of workers turning to them for advice and representation. Against this background, the burden of justifying undercover police intrusion is correspondingly heightened. Nevertheless, it must be said that there are those who, today and over many years, though grudgingly accepting the legitimate existence of trade unions to advise and represent individual members and so on, do not consider as legitimate the essential trade union function of harnessing the collective power of labor to press for improvements to terms and conditions. This school of thought considers that such activity constitutes a distortion of the labor market which should operate free of any such countervailing force. My clients speculate that such an attitude may have played a part in initiating and maintaining covert surveillance of trade unions. So I turn to the role of unions in this inquiry. My clients wish me to express their deep dismay at the fact that it is only now, 5 years after its establishment, that the inquiry is taking evidence. Other core participants have made submissions about this, and I won't repeat them. More disconcerting is the paucity of documents of relevance to my clients, which have so far been disclosed, and that only recently. The disclosure consists of 2 special branch reports on a couple of meetings organized by the International Socialist Party in the early 1970s and 6 annual reports of the Special Demonstrations Squad. Neither provide any evidence of any focus on undercover penetration of any union, save in one particular respect to which I'll come. However, it is known that there has been undercover police surveillance of unions. It's understood that the National Public Order Intelligence Unit included in its remit the monitoring of activities of trade unionists. The Metropolitan Police Special Branch established an industrial intelligence unit, according to the report by Chief Constable Mick Creedon in relation to Operation Hearn and Operation Rubin, which I shall refer to as the Creedon report. The Industrial Intelligence Unit was, quote, formed in 1970 to monitor growing industrial unrest. Officers from the industrial unit use various methods to report on the whole range of working life, from teaching to the docks. This included collating reports from other units, from uniformed officers to the SDS, attending conferences and protests personally, and also developing well-placed confidential contacts from within the different sectors. There is no knowledge or record of the industrial unit using undercover officers. The absence of evidence uncovered by Chief Constable Creedon is not conclusive that the special branch did not use undercover officers in relation to trade unions. The fact that it utilized reports from, amongst others, SDS confirms that it did use information from undercover police officers. It is also to be queried whether the well-placed confidential contacts were made aware that they were supplying information to special branch officers. If not, those officers were working undercover. Some, like Jack Winder, Director of Intelligence and Research at the Economic League, which I'll mention later, was obviously well aware of the nature of his regular meetings with a detective sergeant of the Industrial Intelligence Unit in pubs local to New Scotland Yard, as Chief Constable Creedon reports. But these contacts apparently included union representatives, most of whom, it might be thought, would be reluctant to provide information if they'd realized that they were speaking to special branch officers. Later, Chief Constable Creedon explains that sources were referred to as contacts. My clients conclude that, put shortly, Special Branch's Industrial Intelligence Unit was, amongst other activities, spying on trade unions. The Metropolitan Police Special Branch was amalgamated with the Anti-Terrorist Unit in 2006 to form the Metropolitan Police Counter-Terrorism Command. The Creedon report says that the modern equivalent of the Industrial Intelligence Unit is Operation Fairway, and the National Domestic Extremism and Disorder Intelligence Unit's Industrial Liaison Unit. Whether this falls under the Counter-Terrorism Command is not clear, but the inquiry may be assured that trade unions, already deeply unhappy that they've been under police surveillance, will be horrified to learn that the surveillance of them falls under domestic extremism and disorder. Their reaction, if the responsibility turns out to be that of the Metropolitan Police Counter-Terrorism Command, may be imagined. Sir Peter Francis, an undercover police officer who served in the SDS from 93 to 1997, has said that he carried out covert surveillance of members of the National Union of Teachers, now the NEU, the CWU, the FBU, and Unison. Another undercover officer, Mark Jenner, posed as a joiner to become a member of UCAT in 1996 to 1998. Senior union officers, many now retired or dead, such as Ken Cameron, the former General Secretary of the FBU, believed that they were spied upon by undercover police officers. Some of the women corps participants who were subject to relationships with undercover police were also active trade unionists. For example, we understand that Helen Steele was a Unison safety representative and sat on a Unison national committee. Donna McLean, who was a T&G shop steward working in the homelessness sector, and Alison was a NUT representative in Islington. At this point, I must mention the Consulting Association, the TCA as it was known. It was a secret cartel in the form of a limited company set up by a consortium of multinational construction companies to maintain a blacklist of active trade unionists with a few environmental campaigners in the construction industry, with the objective of barring them from work on the sites of some 44 construction companies which paid it an annual subscription and a fee for each name checked against the blacklist. Established in 1993, it took over this work from the secret employers cartel called the Economic League, which had a broader and more political brief, and was founded in 1919. It collapsed in ignominy after media exposure and a parliamentary inquiry. The Consulting Association list included no less than 3,002. Few were duplicates. The Economic League had some 33,000 names in its files. The full extent of the Consulting Association's activities was publicly revealed by virtue of a raid by the Office of Information Commissioner in 2009. The ICO senior investigator has suggested that some of the information found on Consulting Association files can only have come from the police. He said, quote, "The information was so specific and it contained in effect operational information that would not have formed anything other than a police record," unquote. The Creedon report, the focus of which was the SDS, did not find evidence to substantiate that and proposed that such information may have come from other sources. He did, however, find that, quote, "Police, including special branches and the security services, supplied information to the blacklist funded by the country's major construction firms, the Consulting Association and/or other agencies," unquote. It doesn't need to be stressed that virtually the only information of interest or use to the Consulting Association was information about active trade unionists with a view to preventing them gaining employment. This is borne out, this is borne out by a specific telling incident recorded in the Creedon report. An individual sought work with a television company making educational videos. The company also did work for the construction industry and so contacted the Economic League to vet the application. Chief Constable Creedon continues, quote, "The Economic League representative identified X as a left-wing sympathizer and therefore decided to contact Metropolitan Police Special Branch Industrial Unit due to the perceived risk of X's involvement in education," unquote. Chief Constable Creedon reports that the Special Branch Industrial Intelligence Officer, who was apparently assigned to the engineering industry, then made inquiries, presumably by checking the unit's database and, he continued, quote, "returned to the Economic League asking for any further information, stressing the matter's importance due to the possible link to terrorism. This was recorded as a fact by the Economic League representative and passed on to the prospective employer," unquote. In consequence, unsurprisingly, the individual was refused employment on the ground that he had been, quote, "blacked by the security people," unquote. This sad tale only came to light because the person concerned was related to a retired chief superintendent who took the matter up, in consequence of which it appears a thorough investigation was conducted and the issue corrected. The easy way an employee of the Economic League was able to contact a special branch officer in the Industrial Intelligence Unit and then get him to check an individual on special branch files is frankly extraordinary. The fact that the special branch officer then gave the Economic League, a private enterprise body unconnected with the police, confidential and highly defamatory information, which was presumably secret, is yet more staggering. It's reasonable to conclude a systematic pattern of collusion here. It is to be wondered how many job applicants who don't have a relative who is a retired chief superintendent may have lost employment by reason of information secretly held on them and supplied to prospective employers by the police. Two further points are to be noted. The first is that the special branch officer asked the Economic League staff member for any further information. Chief Constable Creedon doesn't record whether he received any, but clearly information about individuals passed both ways. Secondly, the information in the special branch file in this case may not have been obtained by undercover policing and so might be suggested to fall outside the inquiry's remit. My clients would, however, submit that the secret supply of information held in secret police files by a police officer to a potential employer without that fact being revealed to the individual to whom it related is plainly an act of undercover policing, which the inquiry should investigate. The fact that the information was defamatory and incorrect only fortifies the need for investigation. The fact that it didn't relate to trade union activity is purely fortuitous. The vignette provided by the incident is informative. It is apparently not a unique example of the exchange of information, though the redactions in the Creedon report make it impossible to glean much from the other instances cited there, including the application for a job on the Jubilee line found in SDS files, and the regional director of the Economic League who talked of police collusion and the exchange of information. It's obvious that the police must have appreciated that the effect of passing information about workers to either the Economic League or the Consulting Association would be to enable employers to discriminate against active trade union members by refusing them employment. This is a deeply disturbing allegation, which no doubt the inquiry will wish to probe in accordance with question 115 of the list of questions in the Module 1 SDS issues list. Disclosure of the files will be a prerequisite. In his opening, my learned friend David Barr QC, counsel to the inquiry, noted that undercover officer HN 336 provided some peripheral evidence on blacklisting. Mr. Barr said that HN 336 states that he was aware of the existence of the Economic League while serving in Special Branch and understood that the retiring Chief Superintendent of C Squad joined the Economic League. However, he also states that no relationship existed between the SDS and the Economic League. As someone who later worked on Special Branch's industrial desk, he may be able to assist the inquiry as to whether it might have received intelligence from the SDS and how it was disseminated. End of the quotation from Mr. Barr. My clients would like to know a lot more about Special Branch's industrial desk in due course. The passing of information between the police and the blacklisters should not be thought to be of historic interest only. though outside the temporal ambit of this phase of the inquiry, it's apposite to mention here that on the 6th of November 2008, shortly before work began on the Olympic Park, a Detective Chief Inspector Gordon Mills of the National Extremism Tactical Coordination Unit met with personnel from the construction industry, including the Consulting Association. This was investigated by Chief Constable Creedon, who found that the information passed consisted of, quote, open source information designed to highlight the problems linked to protest movements and how NETCU could assist. Unite, however, is not satisfied and points out that within months, the Consulting Association blacklist was deployed by construction employers to vet workers before engagement on work on the Olympic Park. Trade unionists were, in consequence, refused work there. Unite wonders whether personal information on trade unionists in the construction industry could have been passed, if not at that meeting, but as a consequence of it. The Creedon report notes that from 2007, officially sanctioned information sharing agreements, ISAs, were reached with various outside organizations to share personal information. The Creedon report doesn't disclose whether an ISA existed with the TCA, the Consulting Association. In due course, the inquiry will no doubt investigate the propriety of these ISAs. The blacklist in the construction industry is not a matter of hearsay myth. It should be noted that the manager of the Consulting Association pleaded guilty to breaching the Data Protection Act by maintaining that blacklist and was fined the maximum at that time of £5,000. 14 participating construction companies were served with enforcement notices. Furthermore, civil claims were brought in the High Court for the tort of conspiracy and other torts by 771 blacklisted workers against an array of construction companies. On Wednesday, the 11th of May, 2016, shortly before the trial was to commence, settlement was reached between the claimants and Balfour Beatty, Carillion, Costain, Keir, Lang, Sir Robert McAlpine, Skanska UK, Vinci, Taylor Woodrow, and various individual directors of those companies. The settlement involved an apology in court by their counsel, who said this, quote, "The defendants are here today to offer, through me, their sincere and unreserved apologies to the claimants for any damage caused. The defendants apologize as providers of any information and for the loss of employment suffered as a result of communication of information during the operation of the Consulting Association. They also apologize for the anxiety and hurt to feelings caused as a result," unquote. And they paid damages estimated to be around £75 million for the 771 claimants, including legal costs estimated at 25 million, though liability was formally denied. The defendants admitted that, apart from any specific allegation recorded in a worker's file, the mere communication of any information included in the database bore the defamatory message that the worker concerned might pose a risk of unjustified disruption on any site on which he was employed. It was this that ensured unemployment in most cases. Mr. Dave Smith will address you more fully about the role of undercover policing and the blacklist. We look forward to the police files, minutes, memos, and emails relating to it and all other contacts between the police and the Economic League and subsequently the Consulting Association, and the identity of the officers from and to whom information was passed. So my clients have next to no evidence themselves to put before the inquiry, save suspicions. Unions are not top-down organisations and are not organised so as to monitor and preserve information on such matters of undercover police activities in relation to them, even where it was known or suspected. They are thus reliant on those reviewing the documents and those giving evidence to the inquiry. Unfortunately, even before the tidal wave of unemployment now breaking as a result of lockdown and with it the loss of union members, my clients were not in a position to pay for continuous legal representation throughout this inquiry or to monitor disclosure in order to identify evidence of relevance to them. They will therefore be reliant on you and the inquiry team to alert them of matters arising which concern or might concern them. So as to the very limited disclosure so far, there are some matters on which I should comment. And at this point, I would ask if the document handler could put up the single sheet of paper which I indicated at the outset I would like to refer to. So it's document UCPI 7920 -14. It's a report dated the 28th of November 1973 on a conference held by the International Socialist Party on the 11th of November 1973 in Manchester, and it's headed Special Branch. From Mr. Barr's opening, it appears that the report was made by HN 343 John Clinton. The appendices to this report are largely redacted, but evidently record the names and addresses of those in attendance. At Appendix B, that's the page, under the subtitle Organisation, there is a list of acronyms with codes. Those acronyms represent trade unions in existence in 1973. And I'd like to take you, sir, through those, if I may. This follows, I should say, a list of a redacted list of names and addresses. And this section of Appendix B is headed Organisations, as you see. The first acronym there is APEX, which stands for the Association of Professional, Executive, Clerical and Computer Staff. It's given the reference 400-73-155. That union subsequently became part of what is now the GMB union. The second acronym is ASTMS, which stands for the Association of Scientific, Technical and Managerial Staffs. Its reference is 400-73-100. It merged with other unions and ultimately became subsumed into Unite the Union. The third acronym is AUEW, the Amalgamated Union of Engineering Workers, reference 400-73-194. It too merged with other unions and ultimately became subsumed into Unite the Union. At the bottom of the list is the TGWU, reference 400-72-67. That's the Transport and General Workers Union, which is the third of the unions cited, which merged with other unions and became Unite the Union. There are three other unions listed there: CPSA, which is the Civil and Public Services Association, reference 400-72-111. That became ultimately subsumed into what is now PCS. NALGO, which is the National Local Government Officers Association, reference 400-55-98, a union which merged to become part of Unison, and NUT, National Union of Teachers, reference 400-73-107, which merged to become what is now the National Education Union. And so I can help on the other entries there, just to say that 4 lines down, you have Bryant Colour Works. That's a reference to an industrial dispute taking place at that time at that company. You've then got the Communist Party. You've then got ConMec, which is a reference to another industrial dispute at that time. And then below the CPSA, you've got Liaison Committee for the Defence of Trade Unions. That was an unofficial committee of trade unionists who had organised initially against the Industrial Relations Bill and then Act of 1971. And then you see, so you've got a newspaper, the Morning Star, and another newspaper, the Socialist Worker. And then there are references to the Pentonville 5 and the Shrewsbury 24, which I'll mention in just a moment. So it's evident that these codes represent file references. It looks as if 400 is the prefix used for a file on a trade union. The code 400 distinguishes trade unions from newspapers or political newspapers, which appear to be filed under 347, Morning Star 347 7324 and Socialist Worker 347 7039. The second element of the code, the 2-digit code, may well be a reference to the year, meaning that all the file references are to 1972 or 1973, with the exceptions of Nalgo 1955 and Socialist Worker 1970. Appendix B also refers to the Pentonville 5, stating that there are, quote, mentions on various files, unquote. That language is confirmatory that the numbers relate to files, but we can go a little further. The Pentonville 5 were 5 London shop stewards in the London docks, Messrs. Clancy, Merrick, Steer, Turner, and Watkins, who were imprisoned in Pentonville Prison for contempt of court in July 1972 by the National Industrial Relations Court for refusing to obey a court order to stop picketing a container depot in East London. They were released after a few days on the intervention of the official solicitor after the threat of a general strike by the Trades Union Congress. At that time, dockers were members either of the TGWU or the National Amalgamated Stevedores and Dockers, NASD. The latter merged with the TGWU in 1982, which in turn became part of Unite the Union in 2007. The first two references for the Pentonville 5 seem likely to relate to files on the TGWU. It's not immediately known whether any of the 5 shop stewards were members of the NASD. If so, it's possible that the reference with the prefix 346 is to a file on that union, though that would not be consistent with the theory that union files have the prefix 400. Possibly 346 is a reference to a file on another kind of organization, perhaps a periodical, given the number's proximity to the number 347, which we have surmised represents newspapers or political newspapers. The page also refers to the Shrewsbury 24, 473, 169, 3A, B, and 4A. The Shrewsbury 24 refers to 24 building workers, many, but not all of whom, were then members of the Union of Construction and Allied Trades and Technicians, UCAT, which merged to become part of Unite the Union in 2017. Some, depending on their trade, were members of other unions, such as the AUEW or the TGWU, both of which subsequently became part of Unite. There'd been a national building workers' strike over the summer of 1972, which concluded with the union's acceptance of an offer by the employers in September 1972. 5 months later, 24 building workers were charged under the Conspiracy and Protection of Property Act 1875, for a variety of offences, including conspiracy to intimidate, allegedly committed on the 6th of September 1972 during picketing in the strike. 3 workers, Messrs. Tomlinson, Warren and Mackenzie Jones, were convicted and sent to prison in October 1973, and 3 more at a subsequent trial at a later date. The convictions were controversial at the time and since. Indeed, the Criminal Cases Review Commission has now, we understand, referred the convictions to the Court of Appeal. It seems likely that the file references given in relation to the Shrewsbury 24 are references either to AUEW or to TGWU files. Yet it's surprising that there's no reference to a file on UCAT and that UCAT is not mentioned on that page. So the third set of digits in these union files might be thought to refer to page numbers, but this seems unlikely since it would mean that each reference is confined to only 1 page. It seems more likely that the third set of digits refers to sections of the file dealing with specific unions or parts of unions, or perhaps specific events, since if 400 is the generic number for trade unions and the next double digit is the year, there will be no number allocating the file to a specific union, section, or event. We would appreciate a guide to the meaning of the codes as soon as it can be provided. The inquiry may already have that information, presumably the police have it now. My instructing solicitors sought further disclosure in relation to the files, the existence of which have been revealed by this document. On the 19th of October of this year, the inquiry team responded and included the following statement, quote, "We do not hold special branch registry files and are not investigating special branch interest in trade unions, only reporting on them by SDS undercover officers according to the inquiry's terms of reference." So with respect, that response seems to place an unwarranted limit on the task the inquiry has been appointed to carry out. Your terms of reference begin by stating the inquiry's purpose thus, quote, "To inquire into and report on undercover police operations conducted by English and Welsh police forces in England and Wales since 1968, and in particular, to examine the scope of undercover police operations in practice." Under the headings, unquote, under the heading scope, the terms of reference state, quote, "The inquiry's investigation will include, but not be limited to, whether and to what purpose, extent, and effect undercover police operations have targeted political and social justice campaigners. The inquiry's investigation will include, but not be limited to, the undercover operations of the Special Demonstration Squad and the National Public Order Intelligence Unit," unquote. There then follows a definition of the term undercover police operations by reference to the phrase covert human intelligence source within the meaning of section 26(8) of the Regulation of Investigatory Powers Act 2000. Thus, the undercover police activity to be investigated by the inquiry is manifestly not limited to the SDS.
Forgive me for interrupting again, but do you want the picture taken down?
Oh, yes, I'm very grateful, sir. We don't need that any longer. Thank you, sir. The 6 annual reports of the SDS, or SOS as it was known also, are for the years 1969, 70, 71, 72, 73, and 74. The annual reports take the form of letters. They show the principal target for undercover penetration, at least in that period, were left-wing political groups and campaigns. There appears to be no reference to surveillance of trade unions, despite references to various trade disputes forming the backdrop to the activities of the political groups under surveillance. This is curious given the apparent existence of the special branch files referred to in the surveillance of the 1973 International Socialist Conference. This might be explained by the fact that the annual reports are of the small SDS section, whereas the IS surveillance is apparently special branch. The only entry relevant to covert operations in relation to trade unions would appear to be in the 1974 annual report of the SDS, dated the 4th of February 1975. It states that the Shrewsbury II Defence Committee had been, quote, penetrated to a lesser degree, unquote. We gather from Mr. Barr's opening that this report too was made by HN 343 John Clinton. This committee is likely to have been composed of trade unionists and is almost certainly a successor to the Shrewsbury 24 Defence Committee referred to earlier, reflecting the fact that 2 of the original 24 defendants remained in prison in 1974. The assertion of penetration to a lesser degree poses the question as to what conceivable justification there could be for SDS having penetrated it at all. It seems unlikely that anyone in the SDS or special branch can seriously have thought that such a campaign against convictions was likely to lead to the commission of criminal offences requiring the expenditure of the limited resources of the SDS on undercover penetration of it to any degree. The implication drawn by some of my clients is that the purpose of infiltration was to monitor whether the campaign was having any success in accumulating evidence that the Shrewsbury pickets were charged and convicted on spurious evidence for political purposes, as was and remains the widespread view in trade union circles. What appears to be clear beyond doubt from the very limited disclosure so far is that the police held files containing material on at least 7 trade unions. It's an inevitable assumption that they held files on others and perhaps all trade unions, a point to which I return. We assume that the absence of reference to other unions in Appendix B is because no attendees at the IS conference to which the report is devoted were known to be members of other unions. The existence of files, of course, doesn't prove undercover operations, but it's not an unreasonable inference that the files contain material obtained by covert means. The annual reports so far received for the years up to 1974 in relation to the SDS do not claim responsibility for covert infiltration of trade unions. We look forward to the inquiry's investigation of whether there was such activity not recorded in those annual reports. If the absence of evidence of penetration of unions by SDS is evidence that there was no such penetration by SDS, then it most likely was carried out by officers other than those in SDS, at least up to 1974. For the situation thereafter, it is clear that the SDS was involved in covert surveillance of trade unions, since former police officer Peter Francis, in a statement made public on the 13th of March of 2015, stated, quote, "I'd like to take this opportunity to unreservedly apologise to all the union members I personally spied upon and reported back on whilst deployed undercover in the SDS, including those not only engaged in working in the construction industry, but also those in the National Union of Students, National Union of Teachers, Communication Workers Union, Unison, and the Fire Brigades Union. As everything I've previously stated, I'm prepared to repeat all this under oath at the public inquiry, and should UCAT or any other union or the blacklisted campaigners wish me to in any court cases which they might bring against the relevant UK authorities, end quote. We note from the proceedings on Wednesday that Mr. Francis has not yet made a statement to the inquiry, although I think he is listed to give evidence to it. What is now required is the disclosure of all the files held by the police on all trade unions, whether under these or any other references. We assume that the inquiry team have or will pursue such a request with the police. We should like to know or be kept informed of the outcome of that inquiry. So we were reassured by learned from Mr. Barr's opening, where he said that, quote, the inquiry will be considering the extent to which SDS officers were tasked to report on industrial unrest and in particular, the involvement of trade unions in political activism, unquote. He also said, quote, the inquiry will be exploring how and why the SDS reported on trade union related matters and whether it was justified, unquote. We note that apart from the sparse material cited above, he expressed the view that, quote, on the documents and witness statements obtained for phase 1, there is no evidence that any trade union was specifically infiltrated by the SDS, nor is there evidence of direct contact between the SDS and blacklisting organizations, unquote. So beyond what we have summarized in this, and indeed in the other opening statements, we have no other evidence of infiltration by the SDS in the period 1968 to 1973. However, my clients have the gravest doubts as to the accuracy of the proposition stated by my learned friend Oliver Sanders QC for the designated lawyers officers that, quote, SDS personnel did not infiltrate or target justice campaigns, including the Lawrences, members of parliament or trade unions, and were not involved in trade union blacklisting. Justice campaigns, members of parliament and trade unions were only referred to in SDS intelligence reports if and to the extent that they came into contact with those who were being reported on, unquote. So in any event, neither his observation or the previous one from Mr. Barr suggests that the Industrial Intelligence Unit of Special Branch did not conduct undercover policing against trade unions. Its very existence suggests the contrary. Furthermore, there was a close relationship between SDS and MI5 to the extent that most information obtained by the former was provided to the latter. As Mr. Sanders makes clear, he points out, amongst other things, quote, MI5 monitored industrial unrest and mounted interception, eavesdropping, and informant operations against the Communist Party of Great Britain, Transport and General Workers Union, National Union of Mine Workers, and the Campaign for Nuclear Disarmament, unquote. My clients would like to know what other unions were so monitored, and to this end, share with Mr. Sanders his view that his clients recognize, quote, that what matters most is that the inquiry should receive full evidence about the close relationship and cooperation between MI5 and the SDS, unquote. So it's in those circumstances that my clients wait to hear the evidence and to see what further disclosure there will be. Before I metaphorically sit down, I must mention one other matter of concern to my clients, though it's one that formally lies outside, at least on the face of it, the remit of this inquiry. A bill is currently before Parliament, the Covert Human Intelligence Sources Criminal Conduct Bill. It's been referred to by several counsel in their opening statements. though covert human intelligence is regulated by the Regulation of Investigatory Powers Act 2000, the current bill will, if enacted, permit the prior authorization of crimes to be committed by undercover police officers, amongst others. The bill is widely opposed by the trade unions and many others. It seems to them extraordinary that this inquiry, having been appointed precisely to look into the question of police covert human intelligence sources, the government cannot wait even for the evidence to be taken, let alone for you, sir, to report your conclusions on the subject. It appears disrespectful of this inquiry. The unions are also concerned that under the bill, one justification for the prior authorization of a crime is if it's deemed necessary, quotes, in the interests of the economic well-being of the United Kingdom. That's clause 1.5. The unions foresee that no matter that industrial action will be conducted lawfully, the government will regard it, or industrial action in particular industrial sectors, as detrimental to the economic well-being of the United Kingdom, hence permitting undercover police officers and others to commit crimes to prevent, minimize, or disrupt legitimate trade union activity. One justification for the bill is that it's said that the bill will regularize what already happens. If that is really so, my clients wish to know what, if any, crimes were carried out by undercover police officers in relation to trade unions and trade unionists, and trust that the inquiry shares their concerned interests in answering this question. The unions assume that presently no undercover officer could be instructed by superiors to commit a crime. If the bill becomes law, such an officer will be refusing to obey a lawful instruction if she or he refuses to commit a crime when instructed to do so by a superior who has obtained authorization. My clients, highly experienced in disciplinary proceedings, consider such an undesirable situation as a matter of practice at which the inquiry should look within its terms of reference. So there's just one other matter which will take me 2 minutes to deal with, which has arisen today. Finally, then, sir, my clients note that the issue of the non-disclosure of the identity of undercover officers arose this morning. That's not for discussion now. But my clients wish me to make clear that they share the concerns of Mr. Smith and those expressed earlier today by Mr. Scobie and Ms. Brander on that issue. Trade union members need to know the faces and operational names of those who may have spied upon them and see and hear their evidence if their recollections are to be stirred. Thank you, sir. Those are our submissions in opening.